Hello everyone, I'm Andreya Tatenda, and with me here are my fellow colleagues. We are 3-2 students at Herbert Law School, Grace, Zimbabwe, and our facilitator is Mr. Maphosa for the Jurisprudence module. So we'll be taking you through the Chokuramba case, and I'll be presenting on the facts and the issues of the case.
And I'm Portia Mapondera. I'll take you through the Chokuramba judgment.
I'm Farisai Machorani. I'll take you through the reasons for the judgment and the critique on the case.
And I'm Bikita. I'll take you through the jurisprudential point of view in the Chokuramba case.
And I'm Tinashe Muchemwa. I'm going to be concluding and giving an overview of the whole presentation.
As I stated earlier, I'll be presenting on the facts. So here are the facts of the Chokuramba case. The accused was a 15-year-old juvenile who was convicted of rape as defined in Section 65, subsection 1 of the Criminal Law Codification and Reform Act. And the accused raped a 14-year-old girl who was the neighbor, and it was during the night. So the accused was friends with the victim's brothers. On the fateful night, the accused went to the complainant's home to see his friend. Unfortunately, the friend was not at home. When the complainant and their other brothers retired to bed, the accused joined them. The complainant and their brothers were sleeping in the same hut during the fateful night. The complainant was raped during the night by the accused. So the accused was sentenced to receive a moderate corporal punishment of 3 strokes with a rattan cane. He was sentenced on 26 September 2014 on the strength of Section 353 of the Criminal Procedure and Evidence Act, which allows for the imposition of corporal punishment. The section stipulated that where a male person under the age of 18 years is convicted of any offense, the court which imposes sentence upon him may, in lieu of any other punishment, or in addition to a wholly suspended sentence of a fine or imprisonment, or in addition to making an order in terms of subsection 1 of the Section 351, sentence him to receive moderate corporal punishment not exceeding 6 strokes. So these are the facts of the case. We have a 15-year-old juvenile who raped a 14-year-old girl. I'll move on to the issues of the case. The constitutional matter before the court for determination was whether Section 353 of the Criminal Procedure and Evidence Act was constitutionally invalid. The section authorized the imposition of a sentence of moderate corporal punishment on a male juvenile person under the age of 18 years who is convicted of any offense. The matter was brought to the Constitutional Court by way of the procedure for confirmation of orders concerning the constitutional invalidity of any law or any conduct of the President or a Parliament made by the High Court. The other sub-questions arose for the court to be able to answer the main question, which related to inhumane punishment, degrading punishment, and the second question was whether judicial corporal punishment amounted to inhumane or degrading punishment or both. So these are some of the issues of the case. Another issue was whether the law or the conduct of the President or Parliament held by another court to be constitutionally invalid is indeed so. The court is not bound by the other court's order for invalidity. It must satisfy itself upon the interpretation and application of constitutional provisions allegedly contravened by the legislation or conduct concerned that the court accused came to correct the decision concerning invalidity. So here are the issues of the case. Thank you.
Like I said before, I'll be summarizing the Chokuramba judgment. So the court upheld the decision by the High Court, declaring Section 353 of the Criminal Procedure and Evidence Act, the order of the High Court declaring Section 353 of the Criminal Procedure and Evidence Act to be invalid for the reason that it was inconsistent with Section 53 of the Constitution. As shown in the case of State versus Age of Now. Again, the declaration of the invalidity of Section 353 took effect from 3 April 2019, which is the date of delivery of the judgment, from the date Section 353 of the Criminal Procedure and Evidence Act was consequently struck down. With effect from 3 April 2019, no male juvenile convicted of any offense shall be sentenced to receive moderate corporal punishment. The prohibition was applied to sentences to receive moderate corporal punishment that have been already imposed and are waiting for execution. The constitutional invalidity of the corporal punishment Justice Muremba, by declaring in the Chokramba case that there is need to examine the provisions of the new constitution and see if it's still competent for the courts to impose corporal punishment on male juvenile offenders. It takes time to explore and unpack Section 53 of the Constitution of Zimbabwe, such as which prohibits the subjecting of any person, children included, to physical or psychological torture or cruel, inhuman, or degrading treatment or punishment. She correctly points out that while the old Constitution of Zimbabwe had a similar provision in Section 15, in the new Constitution, the right is not limited. This means that as far as use of physical force on another person is concerned, there's no differentiation between adults above 18 years and children below 18 years, as used to be the case in the old Constitution. This acknowledges that children are not half human beings, but are full human beings who, according to Section 81A of the Constitution, have right to equal treatment before the law, as is everyone else. In addition to having a right to Section 81 to be protected from all forms of abuse, including violence. With this constitutional interpretation of Section 53 and 81, as supported by Section 52A, which protect the rights to personal security, and Section 56 on equality and non-discrimination, Justice Muremba correctly concludes that corporal punishment is now unconstitutional in Zimbabwe. With it is the consequent invalidity of sections of the Criminal Code, the Criminal Procedure and Evidence Act 33, and associated policies such as Circular P3534, in so banning corporal punishment in the Chokramba case. It is important to also note that Justice Muremba, in the interpretation of the constitutional provisions on corporal punishment contained in the Declaration of Rights, acknowledges international law on the matter. She conducts an extensive analysis of the above discussed international instruments as they relate to the issue of corporal punishment and highlights Zimbabwe's international obligations arising therefrom. This is a positive development coming from the judiciary in child rights matters, having been done again in the Mutsuri case on the child marriages by then Deputy Chief Justice was Justice Lukmalab.
The reasons for the Chokramba judgment are: 1, precedents, for example, the state versus Nuwe and state versus juvenile; 2, constitutional provisions, including Section 51 to 53 of the Constitution; and 3, international conventions and norms, e.g. the African Charter on Human Rights, the UDHR, etc., etc. That will be. Again, I'm going to take you through the reasons for the judgment, why the Constitutional Court upheld the decision by the High Court ordering invalidity of the Criminal and Evidence Act Section 353. So the first is the nature and extent of human dignity as a general concept. Dignity as a concept has various meanings that have different connotations. It is generally defined as an honor accorded to a person for a specific reason. A person may be accorded the honor because of the respect for the rank he or she occupies in society. The common definitive feature is that dignity would attach to a person because of status. In that sense, it denotes both the status of an individual and the bearing that is associated with that status. Human dignity is different in the sense that it is a special status which attaches to a person for the reason that he or she is a human being. It is the fact of being human that founds human dignity.
Human dignity is therefore inherent in every person all the time and regardless of circumstances or status of the person and even age. All human beings are equal in the sense that each has inherent dignity in equal measure. What this means is that human dignity is innate in a human being. It remains a constant factor and does not change as a person goes through the stages of development in life. The court attempts to define the general aspect of dignity without much reference to external sources to give a much more clearer view on the nature and extent of the right in question. Dignity is in two forms as prescribed by the 2013 Constitution Amendment 20. The first is as a foundational value. Section 3 of the Constitution prescribes human dignity as part of which all human rights to be provided for in the Constitution are bedrocked. As a foundational value, human dignity gives rise to all fundamental rights and forms the essence of each of them. This means in exploring all other human rights and functions of the state procedures, etc., the courts are expected to look at Section 3 as its foundation. The court in its interpretation should give room for human dignity as it supports the fundamental rights as a value and objective of the Constitution. In other words, as a value, human dignity breathes life into all other rights and hence it is superior and should not be tampered with willy-nilly. The second form of human dignity as a fundamental right, which is non-derogable. Section 51 of the Constitution provides that every person has inherent dignity in their private or public life and the right to have that dignity respected and protected. This right is classified under Section 86 as non-derogable, i.e. rights that cannot be limited. In other words, there are no means, legal or illegal, that can justify another person's limiting the right to dignity. Human dignity asserts the worth of a person who is imbued with it. We cannot define what a human being is without recourse to an essential characteristic such as human dignity. The court further went on to write the reciprocity of human dignity, finding that judicial corporal punishment constitute inhuman or degrading punishment would provide the basis for the determination of the primary question on the constitutional validity of Section 353 of the Criminal Procedure and Evidence Act. Section 353 of the Act, of course, the source of the authority for the imposition of sentence of moderate corporal punishment of male juveniles convicted of any offense was not for the court or call to go outside its mandate and determine questions of constitutional validity of other types of moderate corporal punishment. Questions of constitutional validity of moderate corporal punishment inflicted on juveniles in schools and in homes by their parents, legal guardians, or persons in loco parentis did not fall to be determined by the court in the automatic review proceedings. The court was exercising review powers in respect of the constitutionality of legislation authorizing the imposition of a sentence of moderate corporal punishment on a male juvenile convicted of an offense. Submissions made on the correctness or otherwise of the decision of the court on matters that were not for its determination are not relevant to the determination of issues before the court. Nothing further shall be said about the matters relating to constitutionality of corporal punishment administered in schools and by parents and legal guardians. It is right that courts are generally loath to determine issues not brought before them. The Court of Justice took the positive stance and refused to spread its wings to allow the eradication of corporal punishment to children and took a narrow approach in its application of the law. In this, the Concord could fail to protect the child they protected from judicial corporal punishment who may face the worst fate at home. In addition, the court held that there are other non-physical forms of punishment which are cruel and degrading and thus incompatible with conventions that were ratified by Zimbabwe. These include, for example, punishment which belittles, humiliates, denigrates, scapegoats, and threatens and scares or ridicules the child. Such types of disciplining a child in the home, school, and as a sentence for juveniles as described above are very common and acceptable, mainly in African countries, including Zimbabwe. While beating up or torturing an adult in any of the ways mentioned in above definition is regarded as inhumane, degrading treatment, and unacceptable, and in many cases called a punishable crime of assault or torture. It has a long time remained acceptable when it involves children under the guise that it is for disciplinary purposes, even though the act of discipline involves the infliction of pain. According to UNICEF Uganda, attributes the continued use of corporal punishment to certain entrenched social norms and societies such as spare the rod and spoil the child from religion. Without pain there is no gain, as well as those who turned out well in life are so because they were beaten as children, as well as a person in authority has to exert control always. We move on to the definition of corporal punishment. According to the United Nations Committee on the Rights of Children, the definition of corporal punishment is any punishment in which physical force is used intended to cause some degree of pain or discomfort, however light. Most involves hitting, smacking, slapping, spanking children with the hand or an implement, whip, stick, belt, shoe, wooden spoon, etc. But it can also involve, for example, kicking, shaking, or throwing children, scratching, burning, scalding, or forced ingestion, for example, washing children's mouths out with soap or forcing them to swallow hot spices. In similar terms, it can be referred as punishment by inflicting blows to the offender's body. The substantive.
On the other hand, we have a constitution which, according to Section 2, is the supreme law of Zimbabwe, and all laws and practices need to adhere to it lest they are struck down. Section 51 of the Constitution, it guarantees the right to dignity for every person living in Zimbabwe. Read together with Section 53, which makes it unacceptable to subject any person to torture or any inhuman treatment. It is against this backdrop that corporal punishment, as discussed earlier under the code, was outlawed, as it was against the Constitution, and the court were of the view that freedom from torture as well as dignity were absolute rights which cannot be stripped of any person. This is also evident in the United Nations Convention on the Rights of Children, as discussed earlier. However, it must be noted that in recent years, there is a public outcry to reintroduce corporal punishment, as evidenced by the recent request by the Senate of Zimbabwe, who advocate that that children were now going rogue, doing all bad and criminal acts such as drug abuse and sexual activities at an early stage. So who knows, it could be soon that the court overturns its view on corporal punishment, because it is a very controversial issue that affects society, and usually the court is a problem because it needs to make sure that it balances the needs of the society on the one hand and the needs of the law and the constitution to be upheld. So at the present time, I'm Tinashe Muchemwa, and like I said, I've taken you through the conclusion of the whole presentation that has been done by my mates. Okay, so in conclusion, one needs to take cognizance of the fact and the controversial issues relating to corporal punishment. So we are saying, on one hand, we have an African view that is saying children need to be beaten to be straightened up, and on the other, there is a constitutional right that is prohibiting torture and that is upholding dignity. So we can see that these two are at loggerheads, and this is one thing that brings about the jurisprudential issues that have been discussed earlier by my mates. Okay, to Kata.
Malawi incorporated the dictates of all the international instruments, thereby following the doctrine of universality as propounded for by natural law theorists such as Cicero, Thomas Aquinas, and many others, that there cannot be different laws from the Rome and the Athens. According to positivist theorists, law is law whether just or unjust. And they also propound that law cannot be separated from morality. And the proponents of this view are Hart, Austin, Hans Kelsen, and among others. The decision by the Constitutional Court to confirm the High Court decision resonates very well with the doctrine of the pure theory of law according to Hans Kelsen. Hans Kelsen tells us that for a norm to be valid, it should be validated by another norm. For example, for a statutory instrument to be valid, it should be validated by a parent act. A parent act to be valid, it should be validated by the Constitution. The Constitution to be valid, it should be validated by a previous Constitution. And the previous Constitution to be valid, it must be validated by the grand norm. That is the presupposition of just of thinking. So, this also follows the view by Austin that law is a command from a sovereign that is backed by sanction. The High Court just followed the law as it is, not the law as it ought to be. Although this is against moral dictates that children should not be subjected to corporal punishment, as that infringes their right to dignity, for it is inhuman and degradable. Thank you. Like I said, I'm taking you through the jurisprudential view in the Chokuramba case. The view by natural law theorists that law is from God, law is universal, law is derived from the Creator, who is the only promulgator, and also that law cannot be separated from morality because of the doctrine of common good. And in S versus Chokuramba, international instruments were referenced to: the United Nations Convention on the Rights of the Children, the ICCPR, the Beijing Rules, the CRC, the Trias case, as well as the case of State versus Willard and others of South African jurisdiction. This answers the philosophical question of whether international law is law. Section 46 talks about the interpretation clause, which allows the court to take into account international law. Our supreme law of the land authorizes the Beijing rules and other rules regarding the best interest of children. By inflicting corporal punishment on a juvenile, obvious it will bring some pain in him, while he is not yet physically or mentally mature. Because honestly speaking, the state does not have the resources to accommodate rehabilitation centers for minor juvenile offenders. Let's face it, we are a developing nation, and we know that the government is even failing to provide basic medical facilities.
Once again, this is the end of our presentation. I hope you find the video interesting and helpful. So if you have any questions, any comments, hit the comment section below. But please don't forget to like our video and subscribe, because we'll be posting more videos on this channel. Cheers.